What is intoxication in criminal law? Intoxication refers to a state where a defendant's mental or physical faculties are impaired due to the consumption of alcohol, drugs, or other substances, affecting their ability to form mens rea. Intoxication is not a defense in itself, but may negate mens rea for certain offences. Is intoxication a defense of criminal liability? The answer is no. Intoxication is not a standalone defense. It is only relevant where it prevents the formation of the required mens rea. How is intoxication classified in criminal law? Intoxication is classified into voluntary intoxication and involuntary intoxication. What is voluntary intoxication? Voluntary intoxication occurs where the defendant knowingly and willingly consumes alcohol or drugs. This includes alcohol, illegal drugs, and dangerous drugs taken knowingly. What is the legal effect of voluntary intoxication in the UK? It depends on whether the offence is one of specific intent or basic intent. Now, what is a specific intent offence? A specific intent offence requires intent beyond the act itself, usually a purpose or ulterior intent. Examples are murder, intent to kill or cause GBH, theft, robbery, burglary with intent, as well as fraud. How does voluntary intoxication affect specific intent offences in the UK? If intoxication prevents the defendant from forming specific intent, they cannot be convicted of the specific intent offence. However, they may still be convicted of a lesser basic intent offence. See the case of Regina against Sheehan and Moore, 1975, in which drunken defendants lacked intent to kill and murder was reduced to manslaughter. What is a basic intent offence? A basic intent offence requires only recklessness or negligence, not a higher intent. Examples are assault, battery, criminal damage, as well as manslaughter. How does voluntary intoxication affect basic intent offences in the UK? Voluntary intoxication is no defense of basic intent offences. The reason is that getting drunk is itself reckless. See the case of DPP against Majewski, 1977, in which a voluntary intoxication is no defense to basic intent crimes. What is the policy reason behind this rule? The reason is to prevent individuals from escaping liability by self-induced intoxication. Now let's turn to involuntary intoxication. What is involuntary intoxication? Involuntary intoxication occurs where the defendant did not knowingly consume the intoxicating substance. For example, spiked drinks. Another example, prescription drugs taken as directed, as well as unexpected side effects or mistaken consumption. What is the legal effect of involuntary intoxication in the UK? The defendant is entitled to an acquittal if intoxication prevents formation of mens rea, even for basic intent offences. See the case of Regina against Kingston in 1995, in which even though intoxication was involuntary, liability remained because intent was still formed. The key rule: if mens rea exists, intoxication does not excuse liability. Does involuntary intoxication automatically excuse criminal liability? The answer is an absolute no. It only excuses liability if mens rea is absent. Intoxication and types of drugs. How does the law treat dangerous drugs? Consumption of dangerous drugs is usually treated as voluntary intoxication, even if taken casually. What about prescription medication? If taken as prescribed, intoxication is usually involuntary. But however, if it is misused, it is treated as voluntary intoxication. How about intoxication in Nigerian law? Is intoxication recognized under Nigerian criminal law? The answer is yes, and it is governed by Section 29, Criminal Code, Northern Nigeria, and the Penal Code, Northern Nigeria. What does Section 29 of the Nigerian Criminal Code provide? It provides intoxication does not excuse criminal liability unless the intoxication was involuntary or it caused temporary insanity, or the accused did not know what he was doing. When is intoxication an offense, a defense in Nigeria? Intoxication is a defense in Nigeria where the intoxicant was admitted without consent, or the accused was insane at the time, or the accused lacked intention due to intoxication similar to UK principles. Nigerian case on intoxication. See the case Regina against Prince Will 1963, in which intoxication is only relevant where it negates intent. Does voluntary intoxication excuse crimes in Nigeria? The answer is absolute no. Voluntary intoxication is not a defense except to negate specific intent. Exam tips. Always classify intoxication first, that is, voluntary and involuntary. Then identify type of offense, if it is specific or basic intent, and ask yourself, was mens rea formed? And support your case with Majewski, Sheehan, and Kingston cases.